isn't that one of the purposes of a line item veto? I mean, I've been trying to think about why you would veto something, and I sort of thought about two categories. There's the over my dead body veto, which would, I'm not going to sign this no matter what form you put it in. And then there's the I want you to do what I want you to do veto. I like your ideas, but you didn't write it properly, or there's not enough money, or there's too much money involved. So it's the let's meet and compromise coercive veto.
What we're saying
Aren't those both legal uses of a veto?
No, the second one is not. And the reason is the line item veto has to do with appropriations. You don't get a line item veto to line out items in a public safety bill that you don't like. It's supposed to be an item of appropriation. That's one of the limits. It comes right from the language of the amendment adopting the line item veto. And you have to object to what you're doing. So when he line item vetoed the legislature, he had already sent up his budget proposal, which contained the same amount. All the way through, those amounts stayed the same. So it's clear to us he's not objecting to the $131 million for the legislature. He's just purely trying to get them to the table. And
which again, isn't that one of the purposes of a veto?
No. Well, it can be in other instances, but it can't be if you're holding a gun to the head of the legislature and threatening to obliterate another branch of government. So now, attached to the other letter was a second letter that goes to Kurt Daudt, the Speaker of the House, and Paul Gazelka, the Senate Majority Leader. And he gives a little bit more explanation in this. Once again, dated May 30th, and this is part of Exhibit 1. I am signing into law the 9 so-called budget bills in order to forestall a bitter June showdown over a state government showdown. Then the next paragraph. I will allow the tax bill to become law without my signature. I will not sign it because of very major objections I have with certain provisions in it. Then it says, however, I cannot veto it because of the poison pill provision you snuck into the state government bill. Now, that's just dead wrong. He could have vetoed it. If he thought that was wrong, he should have just vetoed the whole bill, and then the parties would go back into their respective positions and they would negotiate, and we wouldn't be here to talk with the court. He considered other options as well.
You might be here, but you'd be talking about something else.
And it's also interesting to me that he considered another avenue of challenge here. And he said, in a paragraph down, I will not risk a legal challenge to the Department of Revenue's budget and cause uncertainty for its over 1,300 employees. So he looked at all his options at the time and said, well, I could veto it, I can do this, and he chose what I call the nuclear option. I'm going to obliterate you and your ability to conduct business for the next 2 years unless you come to the table. That is an impermissible use of the appropriation line item veto. And we're going straight with the text of the language in the original 1876 amendment. Now, and we have at no place said, Your Honor, that the line item veto itself, that power is unconstitutional. We're saying the way it was used in this case in order to overstep the boundaries of the separation of government is where it goes afoul.
Well, the previous case is discussing the constitutional test for a line item veto. It simply said, is it an appropriation and is it specific and certain? And doesn't this qualify?
No.
On a technical basis, it was a specific and certain appropriate, and it was appropriation. So based on the case law to date, it's technically a valid line item veto, isn't it?
It's an appropriation, I mean a veto of an appropriation, but not in conformance with the 1876 amendment. And that is, you have to object to it. He doesn't object to the appropriation itself. He has communicated that in several different ways. This is, I am going to reach across and I'm going to obliterate you in order to have a better negotiation or negotiating position going forward. Now, if you go to the case law...
So if he had simply said, I object to the legislature's level of funding, I'm vetoing it, that would have been valid.
Well, no, as I said earlier, I thought I could have stopped without talking about their reasons, because you can't obliterate another branch of government. You just can't do that.
Which gets back to the first question I asked you. What constitutionally permissible way, then, does the governor have to rein in what the governor perceives as excessive spending by the legislature on itself?
When I read to you what was going on, where the governor said, I can't veto this bill, he could have vetoed that bill.
No, I'm talking about the appropriation to the legislature.
Listen,
You're arguing that the governor can't veto the legislative appropriation to run the legislature.
If he vetoed, and I know my opponents have put a couple of the costs in there, so there's $3,000 in there for a chaplain, and there's money for state travel and other things. If he had vetoed those and said, I think these are excessive, perfectly acceptable.
But there's no opportunity to do that, because the entire legislative appropriation is in a single dollar amount, one, or actually two, one for each house, without an itemization underneath it. So if you think there was overspending in any way, whether it be a small item or across the board, the only option the governor has is to veto it. And if I take your argument to its natural conclusion, you are then telling the governor you cannot constitutionally control excessive spending.
If the governor said, I'm vetoing it, and I'm vetoing it because I don't like the expensive copiers you have, I would not be here in front of you today. When he vetoes the entire appropriation, it disables my clients from fulfilling their function. So I'm saying this is a very narrow exception. And as I said, in 141 years, no other governor has done this. This is kind of the nuclear option.